All right. Happy Thursday, everybody. Welcome to the latest iteration of the Psychedelic States of America Advocacy Spotlight Initiative, this time with a federal focus on the latest out of Washington with the SSDP-Ramos versus the DEA case, which focuses on the scheduling status of both DOI and DOC, two psychedelic research chemicals that most of you have probably never heard of. But that carry some very significant weight on the future of neuroscientific research and the scheduling process of drugs under the DEA moving forward. So without further ado, I'm just going to jump right in and introduce our incredible guests today, Brett Phelps and Robert Rush, SSDP-Ramos co-counsel, and the great Hamilton Morris, formerly of Vice and Hamilton's Pharmacopoeia, and the other reporter on site with yours truly throughout the scheduling hearing process last November. Guys, thank you so much for joining. Brett and Robert, do you want to get us started with some intros?
Yeah, absolutely. Thanks for having us. My name is Brett Phelps. I'm a solo attorney practicing out of New Mexico, northern New Mexico, and have the pleasure of serving as the general counsel for Students for Sensible Drug Policy. Our science policy committee was one of the petitioners in this case, so that's how I was able to get involved and get to take on this scheduling action together with my co-counsel bestie here, Mr. Rush.
I'm Robert Rush. I'm an attorney. I've got just over 20 years of practice. Worked in a variety of areas. I represent Raul Ramos, who is Dr. Raul Ramos, who's a scientist working on critical research at UC Berkeley involving DOI. He's my client, and my background, I represent a wide variety of clients in the psychedelic space, also hemp and cannabis, emerging technologies. My practice is based out of Colorado, and working with hand in hand with Brett and SSDP, moving this forward. And I've got a new project I'm launching also called the Rights and Reason Project, which we will get to after we get the SSDP, Ramos, DOI, DOC updates done.
Amazing. Thank you, guys. Hamilton, obviously need no introduction, but really, again, thank you so much for being here. Can you tell us a little bit about, how you came to be aware of the DOI, DOC scheduling challenge and what led you to cover the hearings on site in Washington last November?
Yes. I'm generally very interested in prohibition and the mechanisms through which drugs are made illegal. And I think most people have at least a superficial awareness of the fact that drug prohibition is not an effective strategy for reducing whatever harms are associated with drug use, but they're usually only familiar with it in terms of the effect on cannabis or maybe psychedelics like psilocybin and LSD, maybe MDMA. But there's an entire world of prohibition that is basically invisible to the average person because it concerns substances that they have never used, never will use, and have never heard of. But this world is extremely consequential to scientific researchers. And scientists, often by nature, are not interested in drawing huge amounts of attention to themselves in a way that might interfere with their ability to do research. And so there isn't necessarily a huge amount of overlap with drug policy activists and scientific researchers. In the psychedelic space, there actually is quite a bit of overlap, but generally people just do their research and try not to incite the wrath of the government. So the result of this has been hundreds of psychoactive substances and actually a decent number of non-psychoactive substances that just got thrown in being prohibited in such a way that it has terrible effects on scientific research in the United States and internationally. So I think that this particular issue with DOC and DOI is particularly important because these are substances that most people haven't heard of, and because they are so obscure. It is their obscurity that makes it really a fight that is worthwhile. And I don't know if you were asking what they are, but
yes,
the very fact that you have to ask this question, of course, is in and of itself indicative of the nature of the problem, which is we shouldn't even have to explain this sort of thing, right? If we were talking about laws being passed to provide mental health care for people on the street or something like that, no one would have to explain it because it would be obvious what the issue is because people would have seen it. So that we're dealing with something that no one has ever seen, right? No one in the hearing, not me, not the DEA, not the petitioners, have ever seen the problems that we are discussing. It is like a completely abstract issue, but just for the sake of explaining, these are two ultra obscure compounds that are used in scientific research as 5-HT2A agonists. They were developed in the 1970s in Canada. They're very closely related to substances that Alexander Shulgin had made. DOI is sort of the gold standard 5-HT2A agonist in scientific research, in part because it is not a controlled substance, making it something that is accessible to scientific researchers without having to go through a bureaucratic licensing procedure. DOC is not used as frequently in scientific research, but is still valuable. Neither of them have been associated with any kind of meaningful public harms. DOI is so unusual that the government was not able to provide indisputable evidence that a human being has ever used it.
Yeah. And we'll obviously dig into, very shortly here as our kind of a segue, what the actual recommendation that was provided is, followed by really digging into what led to that recommendation, because the recommendation, based on all of our experience being in the DEA court, simply does not seem to line up with the evidence that was provided on both sides. To your point, Hamilton, I think the weaponization of bureaucracy to both limit and enhance research and access to certain research for certain parties is a really important thread here. The unscheduled status of these substances has made them a hallmark in smaller labs, academic labs that don't have the ability to pay for tens of thousands of dollars in Schedule 1 research licensing fees with the DEA and go through that review process. So these are the most equitably accessible 5-H2A chemicals out there, and thus are able to be utilized in a number of really interesting ways and have led to real unexpected novel scientific breakthroughs and discoveries. We'll get to that later with some of the research that our petitioners, the petitioners have been up to. Brett and Robert, can you guys give us a little bit of an overview of what the scheduling recommendation from Judge Paul Sofing of the DEA was, and what that means for what's next?
Sure thing. Yeah. So we've got it right here. This came out Friday morning on World Psychedelics Day. It was a 118-page recommendation that both DOI and DOC be placed into Schedule 1 under the Controlled Substances Act. This is the most restrictive for drugs. The definition for Schedule 1 is drugs with a high potential for abuse and no accepted medical use. Now, we certainly take issue with both elements of that. The accepted medical use, DEA has historically used a very narrow definition of what that can be. There's some other legal challenges going on out there related to that. But where we really think they missed the mark on this one is the high potential for abuse. So this is high relative to other drugs that are in lower schedules. If you look at, benzodiazepines are in the Schedule 3, and those are drugs that do have accepted medical value, but are certainly abused at a much greater rate than these drugs. And so that's just one example, but that was the recommendation. The way that administrative law works is that this now goes to the DEA administrator who will then actually issue a final ruling. So what we are doing right now, have alerts set up on the Federal Register, checking that every day to see when DEA actually makes that ruling official. And then Robert can tell you what we'll do from there.
Yeah, so kind of right now we're in a holding pattern, waiting, getting prepared, because what's coming up next most likely is, the DEA administrator is going to adopt the judge's ruling and move forward and publish a notice of, the final rulemaking on DOI and DOC, adding them to Schedule 1, stopping huge amounts of research, critical research across the country. Everybody who's currently working will need to get a DEA Schedule 1 registration to research these things. And, that's a considerable process, and it's going to interrupt things. In the case of my client, it'll end up stopping his research. He's doing critical research into understanding sensations of touch, how they work, also pain, how it works, because these substances, you have to understand, go well beyond psychedelic like research also into wide areas of neuropharmacological research. So that being said, our next steps are we're going to go into an appeals court, file a challenge to this, and really where drops the ball, I think, and they really just is potential for abuse. Because the DEA has had this interpretation of the law that we strongly disagree with, that for a substance to be in Schedule 1, what you need is it to have some degree of psychoactivity that they call a potential for abuse, if there's any degree of psychoactivity, sometimes not even psychoactivity. And then it's not approved as an FDA drug. And if you have those two things, they move forward, drop it into Schedule 1. There's a third prong, though, that they seem to like to ignore, and that's potential for abuse. And in particular, for Schedule 1 substance, a high potential for abuse. And they just seem to be comfortable with ignoring that entire requirement of that third prong in Schedule 1. And we're going to challenge that vigorously.
Yeah, I think one thread to DOI and DOC's potential research applications that's really fascinating is anti-inflammatory properties related to neuroinflammation. I know a number of advocates in the psychedelic space here in New England that are particularly interested in the intersection of psychedelics and neuroinflammation as it relates to autoimmune disorders, and a number of other chronic pain conditions. And Hamilton is our chemistry expert. Correct me if I'm wrong, but DOI is known as one of the most potent and powerful anti-inflammatories, in science, correct?
I mean, this is, again, one of the ironies of all of this is during the hearing, we heard from David Nichols, who's one of the greatest, if not the greatest, living psychedelic chemist and pharmacologist. And his son, Chuck Nichols, is also an extremely prominent researcher on psychedelics. And Chuck Nichols discovered how powerful these compounds that we conventionally think of as psychedelics can act as anti-inflammatories. And the way that he discovered this was specifically through DOI because it wasn't controlled. I mean, this is a perfect example of how valuable scientific research can result directly from a researcher having access to something. He almost certainly would have used LSD or psilocybin or something like that, but he didn't have access. And so having access to this tool allowed him to make a really important scientific discovery that otherwise wouldn't have happened. One thing that I wanted to just ask is a little bit of a side question, but it's a question for Brett Phelps and Robert Rush. You have this historical precedent in the administrative law judges at the DEA, whatever their ruling is, being ignored. So famously, both cannabis and MDMA were recommended that they not be placed in Schedule 1 by an administrative law judge, and that was ignored. I imagine this is very unlikely, but just from a legal perspective, is there any chance that it could go in the opposite direction, where the administrative law judge says, I think it should be prohibited, and someone at the DEA says, I don't know, these guys made a really good case. Maybe his ruling is wrong. Is that even legally possible?
There's absolutely no reason why the DEA administrator couldn't look at the incredible amount of testimony we presented and look at how we demonstrated that this is not being sold, it's not being used, it's not being abused, and the only use it's being used is in laboratories. And the DEA administrator could absolutely look at that and say, change their mind, we're going to withdraw it, because this is not the first time they've tried to schedule DOI and DOC, and they withdrew their attempt before for a number of not entirely clear but suspected reasons. But yeah, so they absolutely could if they would want to just do the logical, smart thing. We're not holding our breath on that.
And kind of along those lines, though, what's interesting about the timing of this, it is possible. They're not bound by the recommendation. The administrator is not bound by the recommendation. We think that's likely to happen. And as you mentioned in the cannabis and MDMA, at that point, legal challenges were launched. And at that point, the way that federal law worked is there was a huge amount of deference given to agencies for their evaluation of these administrative decisions. And if really there was any substantial evidence that was provided to support that decision, courts would defer to the agency. That was what was known as Chevron deference under a case known as Chevron decided by the Supreme Court. Now, last June, the Supreme Court actually overturned Chevron and said we're no longer going to give agencies that same amount of deference. And so we're in a fortunate situation here where even if the administrator says, yep, that looks good to us, the recommended rulings, and they go with that. And now at the appeals level, it's sort of a fresh review of the entire record and the evidence that was presented. So while we're not holding our breath for what the DEA administrator may do, we are very hopeful in the fact that the appeals court above that, in this case it would be the DC Circuit Court of Appeals, we'll get sort of a fresh review of the entire record. You guys were both there. You saw the evidence as it was laid out, and so there's that possibility as well, and that's something that's due to recent changes in the law.
Yeah. Robert, chime in.
Yeah, no, and interesting enough, the big seminal case there, kind of the only one looking at this, is Grinspoon versus DEA, involving the incredible activist Lester Grinspoon regarding MDMA's scheduling stuff. Ironically, today's the 5-year anniversary of his death that we're speaking, and it's also the 50th anniversary of the discovery by Shulgin of 2CB. So it's an auspicious day here we are on.
Yeah. I wanted to note, that, in attending the hearings, it was pretty shocking how at times Judge Sofing seemed to really give, some pretty solid credence to the arguments that were being made, and even noted, and I think it'd be good to distinguish, there was a precedent set at the end of the hearings last November where after closing arguments, Judge Sofing specifically asked for the SSDP-Ramos counsel to provide evidence of research harms for consideration, which is not something that has been factored into scheduling hearings before, again, because scheduling hearings are typically about, or at least the DEA would like you to think, drugs that are being used and abused. Not the case here. So, Brett and Robert, can you provide some distinction between medical use per the DEA's definition and how that those research harms might factor into the appeals process?
Well, the definition of medical use actually is the DEA and the DOJ are in conflict over what that means. Department of Justice with the cannabis rescheduling has proposed a separate different tests that would look at, state level cannabis medical programs for evidence of medical use, while the DEA maintains this like really rigid 5-part test that they've had since like 1992. Even though the Department of Justice issued a memorandum saying this is like impermissibly narrow. So within the Department of Justice, we have kind of a split going on, which is really strange as an attorney to witness.
And so that that was kind of a hurdle that we ran into in terms of the DEA's proposed, accepted medical uses. Essentially FDA approved, right? And so all of the research that is being done on DOI is preclinical research, which means it's being done on animals, not on humans, and there's not any accepted medical use under that very strict interpretation. There's no FDA approved uses of DOI. However, the judge, as you mentioned, he specifically asked for arguments regarding research harm, and in his opinion, he gives extensive language about the research harms that will occur. He says that undoubtedly research will be harmed. He specifically mentions, Robert's client, Dr. Ramos, as well as Dr. Jason Youngkin was another one of our witnesses who testified that he's actively using DOI. And so the judge did make a finding that there would be research harm. However, he said that was not relevant under the 8-factor analysis. Now we disagree with that, and that's going to be fleshed out in terms of the legal basis for why that's a misinterpretation of the Controlled Substances Act in the appeal, because he did make a finding that research harm was undoubtedly going to occur as a result of scheduling. He just said in his reading of the law, which we disagree with, that was irrelevant.
And one of those factors in that 8-factor test too is what impacts is this going to have the public health. And I don't know how you can possibly say that, stopping research that's trying to figure out how like opioid addiction works and is trying to provide alternative treatments for pain. These are serious things that could have serious wide sweeping effects and help like society and address many of the worst problems that are resulting here with, substance use disorders. And, stopping that's a threat to public health, we believe, and it's not irrelevant.
Yeah, no, great point. I think this is a good segue to talk about the actual body of evidence presented. I would also, just as a quick aside, encourage everybody who hasn't to go listen to Hamilton's pretty riveting podcast series about his covering the hearings on site. Really, really dug into in a pretty jarring way just how slim to none the DEA's case really seemed to be based on the evidence they provided. To break it down to basics, Brett and Robert, can you just give us a brief overview of what the 8-factor analysis is structurally, and then what the 8-factor analysis that both the DEA and HHS provided, what that actually entailed, what they were claiming?
Sure. So the 8 factors, we can go through them one by one, but essentially I don't think that's that helpful because they're very overlapping and related to, is this substance being abused? Does it have medical use? To what amount is it being used? They're really sort of 8 different ways of getting at the general gist of, is this a substance that's creating a public health hazard in that way. And so I think I'll kind of turn it over to Hamilton in terms of what as a scientist and someone who's familiar with substances, what your take was on the evidence that was presented itself.
I mean, the evidence was extraordinarily, laughably terrible that was provided by the DEA because there's no other way it could be. Right. There isn't good evidence to be provided for the harms associated with this because they don't exist. So they had to reach. They had to make extremely tenuous arguments, which revolved around weird interpretations of Reddit comments and things like that, because they just didn't have the sorts of evidence that you would actually expect if something were an issue in terms of public health. For example, I don't think that the prohibition of heroin has done anything to prevent people from using heroin. But if you tasked me with making an evidence-based case that heroin is associated with public health harms, it wouldn't be difficult for me. I could find ample evidence that people have sought treatment for substance use disorder associated with their consumption of heroin. I could find many reports of people that had used doses of heroin that had resulted in them dying, and there would be post-mortem toxicology showing an association between blood levels of heroin and their death. It would be extremely easy, and that is the case for the small number of substances, a number of opioids, alcohol, some benzodiazepines that are occasionally associated with fatal overdoses. You can't do that with these compounds because they're simply too obscure. If you find even one instance, which there was with DOI, it's inevitably going to be a polydrug intoxication with somebody with a complicated medical history, making it hard to even draw any semblance of a firm causal relationship. So the government made a terrible argument because there was no other kind of argument that could be made. There isn't a good argument for them to make. On the flip side, the argument that was made by the petitioners was absurdly good. It was like you couldn't ask for a better case to be made. It was everything. It was every type of person making every type of argument. You had young researchers at the beginning of their career talking about the significance. You had people like David Nichols, who had been there from the very beginning, from the beginning of the existence of DOI, reflecting on the significance at the end of their career. You had people from a military background. You had people who were advocates of psychedelics. You had people who didn't care at all about psychedelics. You had everything, every type of person making persuasive, evidence-based arguments that the prohibition of these substances would be harmful to scientific research and society. And so the thing is, there's like the famous Jonathan Swift quote that's like, you can't use reason to convince somebody to change a position that they didn't arrive at through reason, something like that. Mm-hmm. And this creates a sense of futility where, I'm sitting here in the hearing looking at incredible argument after incredible argument that any reasonable person would look at, and they would say, oh, okay, well, here's another person, another highly credentialed person making a persuasive case that the substance should not be controlled. What more do they want? And my feeling was cautiously optimistic. Sofing seemed, as much as I could tell, because he didn't articulate his internal perspective on these things, he seemed reasonable to me. And my feeling was that if he cared at all about the truth, he would have to rule against the prohibition of DOI and DOC. Yeah. And so I'm very discouraged, and I understand that it would be speculation on the part of Brett Phelps and Robert Rush to say, why didn't this convince him? But I'm curious what you think, because I think there was a feeling among everyone there that this case that had been made was airtight, that there was nothing that could be said that would refute the arguments that had been made. So what do you think happened?
I'm very uncomfortable asking for correction from the great Hamilton Morris, but I believe it was DOC where there was the one fatality, not DOI.
Yes, it was DOC. Did I say DOI?
Yeah.
Sorry. It was yes, it was DOC.
I'm like insane. I'm like, no one ever has used DOI.
No. There was. Yeah. If I misspoke, it was DOC. Yeah. They actually weren't able to provide peer-reviewed medical evidence that a single person had even consumed DOI, let alone died as a result of consuming it. So
and
let me be clear about that.
Yeah, and we'll circle back and provide some pretty jarring examples from the evidence provided that just a ridiculous woot for me comes to mind, which those who listen to Hamilton podcast may know. Robert and Brett, definitely would love to get your thoughts on Hamilton's question, but would also love for those who are unfamiliar. We've talked a little bit about the DEA administrative court process, but there's no jury. It's just us, a judge, and the judge's clerk, right? So it's not really the kind of trial experience that you would expect, and is again really rooted in the DEA's standards. So I just think that's worth noting. This is not like any other courtroom in which you'd expect to have a lot of impartial jurors able to review this evidence independently of a judge and provide their recommendation. Brett and Robert, back to Hamilton's question.
Sure. So I guess I'll, most of my work that I do is in criminal defense, and I have to kind of start by giving the same answer. I get from clients all the time when they ask, like, why is the DA doing this? Like, this isn't fair. Why are they taking this stance on this or approaching this way? And I'll say the same thing I say to them is that if I spend much time thinking about the why on why the government is doing things the way they do, I would not ever be able to get anything else done. The why in this case is baffling based on the evidence that we saw, and I think it's just it's because that's what the DEA does. Like that's how they. That's what they came in there to do. It was in their house, in their courtroom, and the why is because that's what DEA does. They schedule drugs and they enforce scheduling. Beyond that, I don't want to. Yeah, it's hard to say because the reasoning in the 119 pages. Is not super satisfying. But Robert, I don't know
I think there's I got to briefly once ask Rick Doblin, why do you think the DEA is doing this? And he had said, well, because that's what the DEA does. And I thought, thinking more and more, that's actually kind of, I think, to a large degree accurate, because this is what they do. When you're a hammer, everything looks like a nail. And that's I think largely what the DEA does. They don't have an incentive not to schedule things. There's nothing that benefits the DEA in them not scheduling things, because the more drugs are scheduled, the more things are criminalized, the more obligations they have under the law that they can sell to Congress to justify a $3.8 billion budget. So they don't have an incentive really to not criminalize drugs. Why the judge decided to rule this way, and when he appeared to have a very fair and kind of neutral demeanor and looked like he was really interested in exploring the truth and allowed us to present our testimony, which was wonderful. I don't know. It's very tough to speculate, but it is a scary time in this country for judges to take a bold position. And it would have been a bold position for him to take that would have required quite a bit of, courage and character to stand up and say, this is wrong. I'm going to challenge the DEA's administrator on this. And we have a current environment that really does not like administrative law judges who contradict what the agency is looking to do. We've been seeing this, more likely in the, immigration context, but they're all, they're administrative law judges. And I cannot help but think the current, climate of intimidation and fear regarding judges, could possibly have, been a factor.
Very interesting thread to tug on potentially in the future. I, would obviously love to hear from Judge Sofing at some point down the line, though I doubt we will. To bring it very quickly back to the 8-factor analysis, because we had somebody chime in about the HHS's role in all of this. The HHS put together that 8-factor analysis, but that came from data provided largely by the DEA, correct, fellas?
Well, this is kind of part of the weird circular way in that this whole scheduling process works is DEA goes to HHS and says, hey, we have concerns about this drug. Maybe I don't know what they really originally brought to them in this case. In other cases, they're saying we're seizing it. We're seeing it out in the streets more. We're seeing people dying from it or whatever. In this case, they just went to HHS, said, hey, can you guys do this 8-factor analysis? HHS does it and then passes that back to DEA, who then supposedly reviews that and gives their, independent review of that and then adopts it. So the HHS side, they're providing the bulk of the, I defer to HHS on this. Was a typical refrain from the DEA in terms of, kind of putting it on them when they don't offer anyone from HHS as witnesses to explain, their quotes and stories about the rave parties that all this DOI is being seen at and that kind of thing. So it's a very circular process where DEA asks HHS to do something. HHS does it supposedly independently, and DEA supposedly gives an independent review of it and then says, we're basing this based on what HHS told us, which we told them to tell us.
And also, too, there's 8 factors in that analysis. Several of those factors, they clearly came to, they stipulated. They said there is no evidence of diversion from legitimate sources on this. They stipulated to that. They stipulated that there is no medical documentation of human use. They stipulate to these things, and that's not a precursor, and but somehow they still come to the conclusion that it needs to be scheduled, and it seems to be basically they ignore many of those 8 factors and don't really seriously critique them. It just basically, do we think this has a psychoactive effect based upon some animal studies regarding head twitch and things like that? And if we believe that it has a psychoactive effect and it's not an FDA drug, then we just, we throw it in Schedule 1. 5-HTTP has a head twitch response too, but that's not Schedule 1, But I mean, under this paradigm, it could be.
Yeah, I think that's a great, another great segue to a proper explanation of, some of the science side of this. It really seemed like they were wrapping the entirety of the argument around referring back to the HHS and a couple of very narrow definitions for why these substances apply, i.e. the head twitch. I want to shout out Dr. Mario De La Fuente, who had some pretty incredible testimony on one of the final days of the hearings that pushed back directly against head twitch as the golden standard. Hamilton, can you provide some analysis and some clearer understanding for those who might not be familiar with the argument made surrounding head twitch, and also the idea that one piece of evidence of use is enough for evidence of abuse? Some of the standards that the DEA was using to pass off this flimsy argument.
Yeah, historically, a lot of their arguments, and in this instance, were actually dependent on drug discrimination. So the basic idea is you have some substance that is a drug of abuse that they have controlled. And if you can demonstrate responding in an experimental animal that is analogous to the controlled substance, you can say, therefore, this other substance should be controlled because it is eliciting a similar response. So if an animal is mistaking DOC for DOM, you could say, oh, there you go. DOM is a Schedule 1 controlled substance. If DOC is doing the same thing as DOM in a drug discrimination test, it should be similarly controlled. There's a few layers of ridiculousness here. One is that DOM is also a drug that nobody uses. So you create this framework of basically bullshit where even when they provide evidence, the evidence isn't evidence of anything. You're saying, okay, this drug that nobody uses elicits a response analogous to another drug that nobody uses. Therefore, nobody should be allowed to study it scientifically. Like, it's all completely insane. And when Brett Phelps said that he can't ask the question why, otherwise he'll go insane, I'm very sympathetic to that. But at the same time, this is like really a hallmark of fascism. There's a famous scene in the chemist Primo Levi wrote a book, If This Is a Man, and he's in Auschwitz and wants to have an icicle because he's thirsty, and the guard hits it out of his hand and he says, "Why?" And the guard says, "There is no why here." And this is kind of the problem, is you don't want to be in a "there is no why here" place. You have to be able to ask why. And if it makes no sense, people need to point that out. Otherwise, we will all be doomed. And so I think like this entire foundation is completely nuts. Head twitch is, a way of providing pretty robust evidence of 5-HT2A agonist activity, but that in and of itself is really not evidence that something is a harm to public health or something that needs to be legally controlled. If anything, it's evidence of it being a valuable tool for scientific research. It doesn't demonstrate anything at all. So, yeah, I mean, I'm curious. I don't know if this is going to come up anyway, but there's been a lot of discussion about this current administration. Matt Zorn, who has a very public history of challenging the DEA, is now advising HHS and is seemingly sympathetic to what's happening. Is there any reason to think that this current administration could help what's going on?
Good question. If I think for this particular case, because our record has been established, it's going to be difficult unless they're putting pressure on the DEA administrator to go against this ruling. Where I do think, like we talked about, a lot of these scheduling decisions rely heavily on HHS analysis and eight factor analysis. And so, we're hopeful that with Matt Zorn's in there, that maybe they take a more realistic and scientific approach to the 8 factors going forward. In our case, because an appeals court is going off of the record that was established at the trial, it's more of an open question. But bigger picture, I'm hopeful, but it's all TBD.
In theory, they went to schedule kratom several years back, and one of the things they did was HHS changed and they pulled back, and they had originally said it should be Schedule 1. Then they pulled back and they withdrew that recommendation for scheduling on the grounds that it could potentially damage research using kratom, which would be an effective implication on public health. And then the DEA stopped and moved forward. One thing really weird, though, and another thing that'll make the scientists' heads really hurt is it's in lawyers too, is the weird sort of cognitive dissonance in the law, and just utter bullshit, to be quite frank, is it says in the Controlled Substances Act that HHS's decision shall be binding with the scheduling. And HHS is supposed to make the medical decisions. DEA is supposed to be the criminal side of this, an enforcement action. The DOJ then came out and said that shall is binding on the DEA up until the beginning of formal rulemaking. And then once formal rulemaking begins, then the DEA should afford, considerable weight to it, but is not like restricted to it. So it just seems bizarre to me. So they try to interpret the law so no matter what it is, the DEA gets to do whatever the hell the DEA wants to. And I don't think that's the way the law is supposed to work. I don't think that's the way Congress intended it back in 1970 either.
Great. Yeah, one other thing as far as narrow definitions that I think was really interesting is the claim that DOI and DOC had been part of law enforcement seizures, where they'd, seized something that they thought was something else, i.e. LSD or blotter paper, some sort of, substance, and found that it was DOI or DOC, which, again, are unscheduled and not illegal to possess. But referring to that as a law enforcement seizure makes it seem like they're seizing something that's illegal, and the phrasing of that just seemed very slanted in their own favor, which is one of many examples. We've got about 15 minutes left, so I want to be conscious of time and dig into some examples of evidence and how, that was provided on both sides and how the judge chose to, rule. Dr. Elena Jaster was one of the, lead petitioners and an expert witness. She's also one of Psychedelic States of America's, co-leads on this project we've been working on, brilliant scientific mind. And she gave some pretty rousing testimony about her thoughts on the drug war and, drug scheduling in general. Brett and Robert, can you guys talk a little bit about what Judge Schofing, referred to in relation to her testimony and how that factored in, so he said, to his ruling, his recommendation?
Sure. So Dr. Jaster provided testimony specifically related to DOI and some of the promise it was showing in animal studies of actually reducing opioid cravings, and that was something that we thought was very powerful. Then during cross-examination, she was questioned by the DEA attorney about a social media post in which she stated her opposition to the scheduling regime as a whole, and did not believe in the drug scheduling process, basically, and how it was applied. And so, in his opinion, Judge Schofing essentially said that he was not going to consider her testimony specifically related to DOI as credible because of her opposition to scheduling as a whole, and that because of that, her opposition to DOI was a foregone conclusion. Now, I think what's interesting about that, and really unfair to the testimony provided by Dr. Jaster, was that in evaluating the credibility of the DEA scientist, who I think is arguably more of a foregone conclusion, right, in terms of what the DEA witness is going to say to promote their case, that witness was totally credible because she came at it objectively and had no personal stake in the outcome of the hearing, which I think is just patently absurd. That this is a person whose job depends on coming to the conclusion that the people who want DEA to be scheduled want it to be, and so that was a stark contrast. But again, this is something that we will be addressing in the appeal, because Dr. Jaster's testimony specifically related to DOI was incredibly relevant and helpful in terms of evaluating, the public health, specifically factor 6, the public health risk of the scheduling.
Yeah. Hamilton, can you chime in with some thoughts on Dr. Teresa Carbonaro's testimony, the DEA lead witness and their lead pharmacologist, I believe, and just just give us your thoughts on what you witnessed, and I know you've spoken with her before, how that held up in comparison.
I mean, I'm familiar with her work. She's a very interesting person. It's hard. I don't, she does this work. It has very limited evidence that's being used to make this case. It's a bad case that's being made. She's being cautious. I'm like vaguely sympathetic to her on some level. I don't even know why, because it's like, I don't know how she got in this position of doing this. You know, she's at Johns Hopkins. She worked with Roland Griffiths. She knows people in the psychedelic research community. I'm kind of like psychologically curious how she's even in this position of doing this, because it seems like a very scientifically irresponsible position to occupy. And it seems like a betrayal of the research community that she is a part of. But at the same time, you know, maybe she just doesn't know. That's like a kind of a big part of this, is just not knowing how difficult it is. She notably had never applied for a Schedule 1 license herself, and yet is being tasked with articulating this position that it's not difficult to get this license that she herself has never gotten. So it's like, it's just kind of nonsense. I don't know what there is to say about it, really, other than they did these drug discrimination studies, and that is what they're using as evidence, and they seem to be ignoring all other evidence.
Yeah, no, I think that's great. That's really helpful context. I think, from my understanding, Dr. Carbonaro had also, previously worked with Charles Nichols, son of David Nichols, who'd done, some really interesting research on DOI. Another thread there is that he stumbled into using DOI in the aftermath of Hurricane Katrina, if I'm remembering correctly from his testimony, and not having access to substances that he was going to use for some research studies. And in the process of providing that testimony, his father, David Nichols, talked a lot about, how extensive that obtaining a Schedule 1 license process would be. And the DEA made it seem a lot less of a lot less of a hassle than it really is. Can you speak to a little bit about, that disparity between what we heard from David Nichols and the folks who've gone through that process and what the DEA was claiming?
Yeah, and I actually contacted Chuck Nichols after the hearing to verify with him that it did take a year, and he, didn't want to make waves, but confirmed that this idea that it hadn't taken a year was not aligned with his own experience. And this is just standard. Is like there was one person, I'm now forgetting his name, one of the experts, and he was talking about having to send research samples back to the DEA to be disposed of, like after they're done with an experiment. And I was thinking, I had never even heard of this. And I've done very limited work under a license with controlled substances. Just, I guess, to be specific, I remember once I did an experiment where I was using ketamine as a starting material to make variants of ketamine. And then after hearing this, I realized, was I legally required to send back, because the reaction didn't work? Was I legally required to send like the reaction mixture back to the government or something? Like that's how convoluted this stuff is, that people working in good faith with an effort to obey the laws could make mistakes because it's so, and have made mistakes, I know for a fact, because it's so convoluted, they don't even know what's going on themselves. And, I'm calling in right now from Las Vegas in a fancy hotel room that is sponsored by a nicotine company who's sponsoring a power slapping competition where people give each other traumatic brain injuries, sponsored by an extremely addictive drug. And that's like totally fine. No one cares. Myself included. I also don't care. So it's like the double standard is obviously just nuts. Anyone who for a moment thinks that any of this is based on science or logic is deeply confused. And I'm not saying that nicotine should be illegal. I don't think it should be, or power slapping, although maybe, I don't know. But it's just really ridiculous that we're making these arguments about something as clearly innocuous and not a threat to public health as DOI. And with the tiny bit of remaining time, one thing I wanted to ask quickly, Brett Phelps and Robert Rush, there might be other things, but I think like the work that that you two did and that all of the experts did, this was unpaid work. It was immensely time consuming. There's so much energy in the psychedelic world right now, but I think you all have been having difficulty getting support for the work. I think there's a lot of people who feel inspired by what you're doing and want to help and want to be involved. And is there anything anyone listening to this can do to help you all or to support your efforts?
Yeah, it's specifically, I mean, Brett and I we've done this up until this point with, completely 100% pro bono. There's a tiny bit of money that helped cover the cost of flying some of our experts and the cost for like an Airbnb we stayed in. But other than that, I mean, we've never received a dime in compensation for this, and being two solo practitioners who are like kind of providing the, resistance against drug scheduling that could affect, researchers throughout the country. We kind of need more support for this than, what we can just do on our own. That being said, I've created a project now to hopefully provide some support, and then also branch out too, in addition to just providing support for the DOI DOC challenge here, which the project will do, but also to challenge the scheduling of other drugs, because the DEA is not stopping. They've added to a dissociative chemical with hallucinogenic properties, and also a entactogen with stimulant that's kind of, they argue, is similar to MDMA, called 4FA. Added to schedule this month. They are not going to stop, and they're going to keep adding all these drugs. When they find out a drug's psychoactive, they're going to move to schedule it. And we need some sort of a force out there to counter this and to oppose this and defend cognitive liberty and defend science and research freedom. Because if they're not coming after your molecule now and you're researching, they're going to come after it eventually. So I've launched the Rights and Reason project. It'll be, the website should be up shortly at rightsandreasonproject.com. Email at info@rightsandreasonproject.com. Also, there is currently a GoFundMe page that's also been up to kind of initially get this project started and launched. But the kind of the foundation of the project, the fundamental core points are going to be cognitive liberty, justice and equity in decision making, bodily autonomy. It's unseen that we just assume that the government has a right to tell us what we can put into our bodies, how we can operate our minds, because these substances regarding cognitive freedom as a fundamental human right is, cognitive liberty is, these are our thoughts and what we think, and these substances modify that, and we have a right to think whatever the hell we damn well want. In the United States and globally also as an international right for just basic human freedom of thought. These substances are tied to that, and the government doesn't have a right to do this. Also, evidence-based reform, collaboration with other groups, public education, empowerment, and accountability and transparency. A lot of people too, part of it will be a public education effort too, because people don't understand what the DEA does and how they act. They don't understand the complete like fringe aspects of like how they try to pervert science to just continue on this failed paradigm where when you walk into the DEA headquarters, you walk past a wall of faces called the faces of fentanyl, people who've lost children, lost brothers, sisters, family members to, fentanyl overdoses. And what they're doing is the direct opposite of what will put less faces on that wall. And it's also if you're fiscal conservative, this is a huge damn waste of your money. The DEA has spent millions and millions of dollars fighting us on this. Your tax money, why? For a substance no one uses and will hurt science, it will damage the public health. But looking forward to establishing also a database and analyzing, kind of keeping up on all these actions, because they're not publicly known. Unless you're looking at the Federal Register, you don't know what the DEA is up to. And these things are also, too, being scheduled at the state level. This isn't just, there's state level criminalization, and there's huge amounts of efforts across the country to just criminalize large swaths of research chemicals many of which, these people are criminalizing too, have no clue what they're criminalizing. They just see a list of these things. They're told this is bad, drugs are bad, criminalize them. No nuance, no context. Pose that, strategic litigation, develop a network of lawyers working together to oppose this. These are all kinds of the focus of my project. But the very first thing is going to be building out a robust defense to take on DOI and DOC's challenge, because we've opened up the door here, that we've got a great body of evidence, we've got a great record. The law has changed with Chevron deference, that we have opportunities to argue things, and we're looking forward to really aggressively challenging how the DEA interprets the Controlled Substances Act with scheduling.
We're definitely going to go a few minutes over here just for folks still tuning in, 146 strong. I wanted to note there's a couple of other federal challenges related to the scheduling process currently in the works. Attorneys Catherine Tucker and Shane Pennington, who I hope to interview soon, have a petition related to psilocybin scheduling status in the works with HHS, and have also led the federal case to expand access for those with disabilities and who are homebound related to the Oregon Psilocybin Service Center model. Going up against the Oregon Health Authority in relation to that. Guys, any closing thoughts on, where this goes next, the implications here, any final takeaways as far as the evidence that stood out to you, and what you think people should be aware of, and or how they can get involved even beyond financial support?
Yeah, absolutely. So first, huge thanks to all of our team, right? You're hearing from us, but we're only able to do this because of the help we got from our petitioners, Dr. Ramos, Dr. Jaster, Dr. Elijah Ullman, Dr. Tanner Anderson, soon to be Dr. Joe Hennessy, all of our expert witnesses, Dr. Lindsay Cameron, got to see her present some of her amazing work at Psychedelic Science. Dr. Nichols, Dr. Mario De La Fuente, Dr. Joseph Palomar, an incredible epidemiologist who we didn't even get to touch on in terms of his evidence about abuse potential. Dr. Harrison Elder, I think
Dr.
Youngkin, all of those folks. This is an incredible team effort. We are really excited because of the changes in the law. There's obviously a lot of downsides to that in other arenas. But in our particular case, we are excited that we're going to essentially get a fresh review of this evidence and of the way that, the scheduling under the Controlled Substances Act is applied. We could not have, had a better set of facts than what we have. And I don't think we could have established a better record than what we did at the trial court level. And so we're eager to take this to the next steps. Obviously, we would love if it had gone our way at this point, but the bottom line is this fight is far from over. We're in a very unique position right now to really challenge a lot of the underlying assumptions that DEA has been using for drug scheduling and interpreting the Controlled Substances Act for the last 50 years. And so while this recommendation was, it was a bit of a gut punch, we, SSDP and our team, that's what we do is fight. That's what, SSDP and Robert and all of our people have always done. And so, we're not backing down and we're excited for the next steps.
Yeah, much love to the SSDP fam and, everybody with SSDP, passionate group of people who are throughout, if you look at the history of the organization, who's throughout the psychedelic space at all sort of, executive levels in certain organizations, you'll see SSDP related to a lot of them. And, cannot say enough about the scientists also too, participated, the time that they dedicated, unbelievable, especially Elena Jaster, Elijah Ullman, Tanner Anderson, Joe Hennessy, absolutely amazing dedication, and and anybody who I did not mention. But we really need to come together as a community too. Lawyers need to work together, scientists need to work together. We need to realize that we have a common enemy here. I don't like to use the word enemy, but I don't know what other word works for it. and collectively, work against what is just, madness.
Yeah, no, well said. Hamilton, any closing thoughts, and can we expect any future coverage of the proceedings from you and your podcast?
Yes, I certainly hope so. And I plan to see this through, because I think this really is important. You'll never find a better example than DOI of something where there's tremendous evidence for its benefit to scientific research and non-existent evidence for harms to society. So both symbolically and actually, this is one of the best things I've ever seen in terms of really seeing, can we insert reason into this rulemaking process? Yeah. You're never going to find anything better than DOI for this, I don't think.
I agree.
Yeah, so I'm here to examine and support and cover in any way that I can. And as Robert Rush mentioned, there is now interest in prohibiting 4-fluoroamphetamine. They're not stopping. They're just going to continue. They're going to continue wasting people's time and taking away freedom from scientists and interfering with our ability to understand the human brain and harming us in the process and wasting our money and wasting our time. And people should read the Federal Register. They should write comments, carefully constructed, thoughtful comments articulating their position, voicing their opposition. They should organize. They should learn about the law, and they should join these efforts to prevent us from losing access to valuable research chemicals.
Yeah.
Well said as always. Brett, chime in.
Oh, just wanted to, thanks to you guys, both Jack and Hamilton, for, bringing this issue to light. Thanks to the other attorneys working on the same front in different arenas. And yeah, it's a team effort. It's a big old family that's all in this fight together. So, thank you guys. And yeah, thanks to all the other attorneys out there working on this. And thanks, of course, to my co-counsel bestie here, Robert Rush. It's been a pleasure to fight this, and just, happy and thankful to be a part of it and doing what we can for science and drug policy.
Yeah, and thanks to you guys, for getting the word out there about this, promoting this, and, raising awareness. And, one thing I will say is, I don't know how much anything to do with it, but, this has been an effort to defend a psychedelic, and all the people on this team working together and stuff. The amount of collaboration, the amount of actual just focusing on the goal as a team and leaving our egos behind, and everybody just focusing on the end goal, and without, thoughts of kind of ego and self and just selfless actions. It was really amazing. I've never seen such a cohesive, dedicated, hardworking team in my 20 plus years of experience.
It was really one of the most profound experiences of my life, hands down, reporting or otherwise, just to be able to be there in the room. And I am just so grateful to have been able to cover it. And to echo Hamilton, I think it is one of the most important scientific related legal battles of the 21st century. And I think it has profound implications on the future of neuroscience research that we didn't really get to touch on as much today, because I'm sure we could talk for hours, and it seems like folks could listen for hours. So Hamilton, it seemed like you had something you wanted to add here at the end before we sign off.
No, just check out this website that Brett Phelps and Robert Rush are creating. Support them, follow them, stay on top of this. It's not going to go away without people pushing against it. So it's important to stay involved.
Well said. Yeah, we included the link to the GoFundMe that Rob has launched in the comments, and we'll include all that information as well as the website as soon as it launches in the show notes. With some final closing thoughts, just wanted to note that you can expect a transcript of this Q&A to be pushed out through Lucid News in the weeks ahead, as well as a corresponding Psychedelic States of America column recapping all that we've spoken of here, with some additional threads from the scientific experts who testified and provided petitioner support in this process. Thank you so much to everybody for tuning in. We're 150 strong, got a few above that. You'll see this podcast pushed out through Psychedelics Today in the weeks ahead. But until then, I'm Jack Gorsline. This has been the Psychedelic States of America Advocacy Spotlight Initiative, revisiting SSDP-Ramos versus the DEA. Until next time, have a great rest of your Thursday.
Thank you, everybody.
Thank you.